I see the red light. We are on. Good morning. This is the Kansas Court of Appeals oral argument by Zoom. We have three cases on the docket today. I'm Gordon Atchison. I will be the presiding judge. Joining me today are Judge Kim Schroeder, who has been a member of our court since 2013. Before that, most immediately, he served as a district court judge in Southwest Kansas for 14 years. Also joining us is Judge Sarah Warner. She's the newest member of the court. She joined our court last year and was in private practice in Lawrence before then. I just passed my 10th anniversary on this court. And before that, I was in private practice for a long time, mostly in the Kansas City area. Our first case on the docket today is State of Kansas versus Dameon Baumgarner 121092. I will advise counsel that with this format, we are live streaming on YouTube, and this argument will be recorded and archived. Could I have the appearances of counsel, please?
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Dameon Baumgarner.
Yes, Your Honor, I'm Kerwin Spencer. I'm the Sumner County Attorney appearing on behalf of the state of Kansas.
This case is set for the standard 15 minutes per side. I will advise counsel we've read the briefs and are generally familiar with the facts. Mr. Hodgkinson, as the appellant, would you like to reserve some rebuttal time out of your 15 minutes?
3 minutes, please.
You have it. And you're free to start your argument whenever you're ready.
Your Honor, first I wanted to just confirm, I filed a notice of withdrawal of issues 3 and 4 in this case. I just need to confirm that the court got that.
We got it yesterday afternoon.
Thank you, Your Honor.
That may shorten up our questions a little bit, but go ahead.
I apologize for the lateness of that, Your Honor. This is the first case I've had under this particular subsection. So in my colleague's brief, he said, it seems like counsel's writing this with not even knowing this statute exists. And that was right. I didn't know that statute exists before I looked at my colleague's brief in more detail. Anyway, so that leaves 2 issues for us then today. Mr. Baumgarner was convicted in Sumner County of criminal use of a weapon. The specifics of the allegations were that he was alleged to have possessed a firearm after having been, while being or having been a mentally ill person subject to involuntary commitment. So the 2 issues then remaining in this case are whether or not the state proved beyond a reasonable, whether there's evidence in the record to sustain a finding beyond a reasonable doubt that Mr. Baumgarner was such a person and that he possessed a firearm as contemplated by Kansas statute. So the bulk of my argument probably is about issue 1, which has to do with the proof in this case with regard to Mr. Baumgarner's status. And I guess the point that I wanted to make or clarify, sort of buried it in my brief maybe, is that Kansas statute under the criminal use of a weapon prohibition doesn't make it that you can't possess a weapon upon a finding that you are one of these persons. It has to be that you actually have to be one of these persons. So it's not a case where, for example, somebody's convicted of this and you would show here's a journal entry of the conviction, or a person's been adjudicated of something, you can say here's a journal entry of that. The statute requires that the person actually be a mentally ill person subject to involuntary commitment for care and treatment. And that term, those words have a specific meaning. And so my understanding of the record here is the only evidence in our record regarding this is the actual order for outpatient treatment that was admitted at trial. Now, I recognize—
Is your argument with respect to that order, as I understand it, that it's internally inconsistent and therefore is insufficient to establish the required element?
That that's part of it, Your Honor.
Okay, what's the rest of it?
Yeah, certainly the idea here is, and I just want to clarify that my colleague has noted maybe that there could have been other evidence in this regard. and I don't know if that's true or not, but it doesn't matter for purposes of this issue. The sufficiency issue reviews the record that we have in the record on appeal. And to the extent that the order for outpatient treatment filed on September 8, 2015 is the only evidence in this regard, then that's what this court is reviewing. So certainly you're right, Your Honor, that the primary argument in this case is that in order for a person to be a mentally ill person subject to involuntary commitment for care and treatment, you have to be mentally ill and you have to be likely to cause harm to yourself or others. That's part of the statutory definition of that kind of person. And the order in this case said that when he's getting treatment, Mr. Baumgarner is not likely to cause harm to himself or others. And so that there is this sort of mutual exclusion, and such that the evidence as shown here does not show that Mr. Baumgarner is a mentally ill person subject to involuntary commitment for care and treatment during the time of this order, at least. So, and the additional argument here, Your Honor, also, and I don't really think I argued this, but the other point I would just make is that if this is the only evidence, the state had to prove the elements of the crime in the instruction to the jury were that the state had to prove beyond a reasonable doubt that Mr. Baumgarner was a mentally ill person subject to an involuntary commitment for care and treatment. The only evidence put in here was that the district court had in 2015 found by clear and convincing evidence that Mr. Baumgarner was a mentally ill person subject to involuntary care or treatment. And so the combination of these things show that there's insufficient evidence to show that Mr. Baumgarner was a mentally ill person subject to involuntary commitment for care and treatment.
Counsel?
Well,
Oh.
I had a question about that reading through this. It seems to me the latter part of your argument, you're judicially stopped from proceeding on that because in the trial court, there was an objection by Mr. Baumgarner's counsel to any evidence other than the journal entry, and they agreed that that's what would be submitted.
Your Honor, I'm not aware of any authority for the idea that I can be judicially stopped from a sufficiency argument. To the extent,
Well, if the trial lawyer says we'll agree that this is the evidence, and we don't want the state putting on any additional evidence, it seems to me that you are then stuck with that.
That there's no more evidence, but that doesn't affect the sufficiency analysis. I mean, for example, let's say the state says we want to put on this other evidence. We want to have a full trial on this because we have to prove beyond reasonable doubt that Mr. Baumgarner is this mentally ill person subject to involuntary commitment. So we want to put on all this evidence, and the judge says, "No, I'm not going to let you put on that evidence." The defense objects, says, "We don't want that evidence coming in," and the judge says, "Yeah, I'm not letting that evidence in." Well, then the evidence didn't come in. Now, maybe that was a point that the state could have appealed. If that was a pre-trial ruling, maybe they could have done an interlocutory appeal. Or if it was during the trial, maybe the state could have done an appeal on a question reserved. But it doesn't change the analysis of the sufficiency argument. I mean, Kansas case law is clear that it doesn't make any difference whether a party stipulates to the admission of cause of death or things like that in a murder case. The state still has to prove their case beyond a reasonable doubt. And therefore, the sufficiency analysis is exactly the same. So, Your Honor, I guess I take issue with the idea that you can even be judicially stopped from a sufficiency argument.
Okay, well, that's why I asked the question. I'm trying to figure out where you are on this. So, yeah. Okay, all right.
My argument is, even if that's true, and even if the parties stipulate, if we come in and stipulated and said, and this happens in trial, I've had appeals where we have trials on stipulated facts, and I look at the stipulated facts and I say, you know what, they didn't stipulate to all the elements of the crime. And it's still a trial. And there's a sufficiency analysis then. And it doesn't make any difference if the parties stipulated to that evidence and even stipulated that that's sufficient. That's a legal conclusion, not a fact. This court still has a duty to review the record to determine whether there's sufficient evidence to sustain the conviction.
Counsel, could the jury have drawn inferences from the order? in order to reach sufficient, to find sufficient evidence? Are there inferences and circumstantial evidence that could exist from that order besides just the order itself?
I'm not sure what they are. I mean, obviously, Your Honor, juries are allowed to make reasonable inferences from fact. I mean, that's certainly a true statement. But particularly given the nature of this order, I'm not sure what inferences the jury would be allowed. I mean, it's interesting to me. Can a jury infer from a finding by clear and convincing evidence that something's true beyond a reasonable doubt? That's an odd proposition to me. And can a jury infer from a finding that a person is not likely to be to cause harm to themselves or others, that they will likely cause harm to themselves or others? But that doesn't seem like a reasonable inference to me. And that's the crux of our argument on that point. Your Honor, I don't have a lot to add to the second issue, the second sufficiency issue, which has to do with whether there's actually evidence that my client ever possessed the weapon in question. I think the facts are set out there and the standard is set out there for the court to decide. I mean, I reviewed the record this morning as I was sort of wondering if, in light of my colleague's argument, have I overstated things? But every witness in this case said they did not see Dameon possess that rifle. So this is some sort of a constructive, I guess, possession argument. And I don't have a lot to add to it, that the fact that I might suggest to somebody or as a group say, let's, if I wanted to buy a gun for somebody when I know I can't possess a gun, I'm not admitting that's this case, but if it was this case, I'm like, I can't possess a gun, but my people in my family can. So, I'll talk to them about that or have conversations with them about them possessing a gun. That's not, and our argument is that's not constructive possession, that Mr. Baumgarner possessed that gun in light of the record.
Okay.
Your Honor, that's all I have for my presentation this morning.
That's fine. You have your rebuttal time.
Thank you, Your Honor.
Spencer, whenever you're ready.
Thank you, Your Honor. Your Honor, I was looking again at the jury instructions and the statute just a few minutes ago. And for the jury instructions and reading from 159 of the transcript, the defendant knowingly possessed a firearm and the defendant was at some previous time a mentally ill person subject to involuntary commitment for care and treatment. So that's what the jury instructions were. That jives exactly with the 216301 sub 13, possessing any firearm by a person who is or has been a mentally ill person subject to involuntary commitment for care and treatment as defined by KSA 592946. So we actually introduced into evidence the certified copy of the previous mental court adjudication as being a mentally ill person subject to an involuntary commitment. And then also in the jury instructions, the jury was instructed what those things mean. And there were in footnotes on the on that same jury instruction I read from earlier. Mentally ill person means any person who is suffering from a mental disorder which is manifested by clinically significant behavior and so forth. And then also the definition of mentally ill person subject to involuntary commitment for care and treatment means a mentally ill person who also lacks capacity to make an informed decision concerning treatment, is likely to cause harm to self or others, and whose diagnosis is not solely one of the following mental disorders. And I'm not going to read the mental disorders. But what I argued at closing, in which the jury, I believe, accepted, was they need to look at that journal entry and see if the magic words mentally ill person subject to involuntary commitment for care and treatment were in the findings made in the earlier civil case.
But let me ask you along that line, what's your response to Mr. Hodgkinson's argument that the magic words in the journal entry are by clear and convincing evidence, and the standard required in the criminal case was beyond a reasonable doubt, and therefore the journal entry alone was insufficient.
Well, the only way that that could be accurate is if we're allowed to go in and prove each and every element a retrial situation, because you're not going to have a journal entry that says this has been decided beyond a reasonable doubt. And this case was also somewhat complicated with the fact that back in 2015, the defendant discharged a firearm within the city limits. Ended up, he was mentally ill as he did that. And so it was defense counsel strategy that they didn't want to let in the details of use of a firearm while mentally ill, or at least not all of the details anyway. And so the court, as an accommodation to defendant, would not let me, for instance, have the probation officer testify that as a part of that probation, he was in counseling and that he was prohibited from having a firearm as a part of that probation as well. So, and I understand that ruling, but then that just leaves us with the fact that that journal entry, original journal entry, clearly says that there's been a court finding by clear and convincing evidence that the defendant was a mentally ill person subject to involuntary commitment. Then we had to certainly prove beyond a reasonable doubt that this is that same defendant. But we did that. We had Captain Nefsker testify that Captain Nefsker was one of the.
Well, I don't think there's any doubt about that. I mean, I suppose if the journal entry was John Smith and the defendant was John Smith, you could argue there were a bunch of John Smiths running around, but that's not the issue. It does seem to me, though, that proof by clear and convincing evidence of something is not sufficient to establish that beyond a reasonable doubt. And Mr. Hodgkinson is saying that's a real problem now. And I'm trying to figure out why that isn't a problem.
Well, if we look at the statute where it says possessing any firearm by a person who is or has been a mentally ill person subject to involuntary commitment for care and treatment. So if a court has adjudicated him as such, then we can, as long as we prove beyond a reasonable doubt that the court has adjudicated him as such, then we've complied with the right burden of proof. The fact that the court might have had a other lower burden, one doesn't mean that.
Well, that would be true if the criminal statute spoke of the element being an adjudication as a mentally ill person, but it doesn't say that. It does seem to refer to the status of being a mentally ill person, not an adjudication. Now, what I was actually wondering more about is whether there's an invited error problem here.
Well, well, yes, there certainly could have been an invited error problem in that it was the defense counsel's strategy to keep us from going into that because he didn't want to hear a probation officer's testimony that they, as a part of his probation, he had to have counseling and so forth. Maybe we potentially could have had the counselor come in and testify as well. That didn't occur to me as a likely avenue. The fact that he had to go through the counseling in order to, and we also had some discussions about the fact that there was a review hearing 3 months later, and then another review hearing 3 months later. Court made the same determinations, and we did not introduce those other journal entries because it was the fact that it's no more illegal because there's been 3 adjudications of being mentally ill subject to involuntary commitment rather than just one, especially where those 3 determinations are all in the same civil commitment case. And so we had some discussion about that in front of Judge Mott, and Judge Mott came to the conclusion, rightfully so, that we should only go with the first adjudication because that is what classifies the defendant as being within the subcategory of people that are not protected by the Second Amendment. But so I don't know if that answers the question or not, but I don't think I've got any better answer than that anyway.
Okay. Well, I guess what I have not, and I probably will look in more detail at the trial record here, but you were trial counsel.
Yes.
You were prepared to put on more evidence about Mr. Baumgarner's mental status. The defense said, we don't want that in, and asked the judge to exclude it because it would be prejudicial, and the judge agreed, and you were not allowed to put on that additional evidence. Is that correct?
Right. That's exactly what happened.
Okay. Now, is there a proffer, or is there some place in the record where we can see what that evidence was that you were planning to offer that was excluded, or is that apparent from the colloquy among counsel in the court?
Well, there is a transcript of the preliminary hearing that's a part of the record, I believe. And so we put in on significantly more evidence on that issue at the preliminary hearing. So you can look at that to describe the situation. And also at the start of the jury trial, we were debating the language that Mr. Brown who was trial counsel, had drafted for the order in Lamine, reference a hearing we'd had some month and a half earlier, where the court ruled that prior convictions of the defendant would not be admissible. And so I was prepared to have the probation officer testify to the fact he was a court service officer, not calling him a probation officer, and to discuss with him the counseling that the defendant had been through and what his requirements were, and that he met with the defendant once a month. And that was very similar to the testimony of that probation officer at the preliminary hearing. But Judge Mott said, no, we're not going to do that. We're not going to let you introduce the fact that he was convicted of discharge of a firearm within the city limits for the same occurrence that also resulted in his adjudication as being a mentally ill person subject to involuntary commitment. So those would be the two places where you could see the evidence that was kept out.
And if I understand matters, you were not proposing bringing in a mental health provider to testify as to Mr. Baumgartner's status at any point along the line.
No, and there might have been privilege for the mental health provider to not be able to testify to what they discussed in the counseling. I wasn't trying to make this, overcome whether or not there was a privilege there. So I was not going to do it through the mental health provider.
Okay.
Counsel, could you remind me, when you introduced this journal entry into evidence, what was the context in which you did that? Was it stipulated? Did that come in through testimony? How did that come in?
We discussed that as we were discussing the language for the order in Lamine, and Judge Mott made a record with Mr. Brown that Mr. Brown did not object to the journal entry, because I think Judge Mott thought that it was a foregone conclusion that the state was going to have to use that journal entry, or if there was a legal reason to keep it out, then he was going to maybe allow me to go into the underlying reasons or the evidence that was introduced at that original hearing. So Judge Mott made a careful record immediately prior to the jury trial commencing that, one, the defendant did not object to the introduction of that journal entry. And then just after opening statements, I offered a certified copy of that journal entry into evidence. Mr. Brown said no objection. So the jury heard it go in that way and heard Mr. Brown say he had no objection to that journal entry. And then later, when I had Captain Nesker testifying about the earlier situation, Mr. Brown then objected and said, well, that journal entry has already been into evidence. So Captain Nesker's testimony about the earlier incident is irrelevant. And my response was, Judge, I'm just trying to prove that this is the same Dameon Baumgarner on that earlier issue as we now have here in court. And Judge Mott said, all right, I'm going to overrule the objection, but get directly to that identification, please. So I proceeded in the next two questions to merely cover that identification and then moved on from there and didn't go into any more details about what the underlying manifestations of his mental illness were, hallucinations and such. We didn't have any discussions about that prior incident involved hallucinations, that he was shooting at people that he thought weren't there and nobody else could see him. So, you know, I didn't get to go into that. And, you know, it was because the defendant did not object to that adjudication on its face, which just has the fact that he's mentally ill, subject to involuntary commitment, as opposed to, for these reasons, he was acting crazy in this manner. So I didn't get to go in and say, proceed to have Captain Nesker say, well, these are the reasons that he ended up taking him to Lawrence State Hospital that day.
Okay, you're at about the end of your time. We barely touched on the possession issue. Do you have a minute that you want to say something about that, or?
Yes, please.
Right.
I just wanted to, we have an instruction that this was same type of instruction that we use for possession of marijuana cases. Having ability to control and some measure of access to, and I won't try to read that instruction to you, but it is there, and that's right out of PIC. So we follow the PIC instructions. Then the fact that the defendant had a sister who had come to pick up the rifle at his father's request because his father didn't want the rifle there anymore. He then calls the sister after she's left with the rifle saying, bring that rifle back. I'm going to give that to our brother on his birthday, and I want it back here in this house until I do that. She brought it back there, so he had some measure of control over it. It was kept in a place where he had access to it, and that was, the jury determined that that was sufficient to show that he was therefore in possession. And I put it in my brief, there's not a requirement of carrying. Possession is a different situation than carrying, and I'd refer back to the brief on that since I'm out of time.
All right, thank you. Mr. Hodgkinson, you have 3 minutes.
Your Honor, I just wanted to follow up on maybe on your point and your questions for my colleague that, I mean, when I think about, does the fact that my client may have objected to some evidence come in mean that, you know, he can't then complain about or make a claim about sufficient evidence on appeal? And I just don't think there's any authority for that idea. In fact, that's why we have an interlocutory appeal process, because we know sometimes the state, you know, let's say I move to suppress some evidence in the middle of a trial, and you know, the judge grants that in the middle of the trial. Now the state's in a pretty bad position because they're in the middle of the trial, and now the record would say there's insufficient maybe evidence of something.
Well, it sounds to me like we're on the cusp of, again, whether it's judicial estoppel or invited error, and I don't know that it depends on exactly how the request was made or what the judge ruled, but obviously the defense, as a strategic matter, asked to preclude some evidence bearing on Mr. Baumgartner's mental status at the time. And I'm not quite sure how you then turn around and argue on appeal an insufficiency claim with that in the record.
Because the only function of this court on a sufficiency review is to review the evidence that was admitted and determine whether or not that's sufficient to support all the elements beyond a reasonable doubt. Anything else, I mean, yeah, there's a way to invite this kind of error. You plead to the case, or maybe you stipulate to the elements of the crime, although I think there may be some additional procedural steps that you have to take in order to actually procedurally stipulate to them and take them away from the jury. That's not what happened in this case. The jury was instructed that they had to find all of these elements of this crime, and therefore this court should review to determine whether there's evidence admitted in this record to support the elements of that crime. That's what we believe a sufficiency review is. I don't believe that there is a way to invite that error.
Okay. Anything else?
No, Your Honor, thank you.
All right. I appreciate the argument of both counsel. We will take this under advisement and